$15,000. That was the amount Christopher Brestelli agreed to accept in exchange for removing a fence that had already triggered years of arguments between two neighboring lakefront properties in Connecticut. The settlement was signed, the money was paid, the fence came down. For a brief moment, Benjamin Whelan believed the dispute was finally over. Then, he looked toward the lake and froze. Another fence was already going up. Years later, a Connecticut judge would be asked a simple question. When Christopher Brestelli accepted that settlement, did he ever intend to honor it? Because by then, the dispute had grown far beyond a single fence. It involved surveillance cameras, drone flights, property rights, and a legal battle that neither neighbor seemed willing to end. This is the real story behind Whelan versus Brestelli. The first argument in what would eventually become Whelan versus Brestelli wasn't about a fence. It wasn't about a lawsuit, and it wasn't about the lake. It was about a wedding shower. In 2018, Christopher and Virginia Brestelli purchased the lakefront property next door to Benjamin Whelan's home in Connecticut. At first, nothing seemed unusual about the arrival of the new neighbors. Shortly after the purchase, Whelan introduced himself. According to court records, the conversation included topics that would later become surprisingly important: the lake, access to the shoreline, and how the neighboring properties interacted with one another. At the time, it was simply a discussion between neighbors. No lawyers, no court filings, no legal threats, just a conversation near the water. If anyone had suggested that the relationship would eventually end in years of litigation, neither side would have believed it. Then came the wedding shower. Not long after moving into the property, the Brestellis hosted a large gathering for their son, Travis. Family members arrived, friends arrived, cars arrived. As the event grew, so did the number of vehicles being parked around the neighborhood. Some ended up near areas that Benjamin Whelan believed should remain clear. What started as a minor disagreement quickly became something else. Questions turned into complaints. Complaints turned into arguments. And before long, the two neighbors were standing face to face. The dispute had nothing to do with fences. Nothing to do with property boundaries. Nothing to do with lawsuits. It was simply an argument about parking. But it became personal. Very personal. Years later, when judges reviewed the history of the dispute, one moment from that confrontation still appeared in the record. At some point during the argument, Christopher Brestelli told Benjamin Whelan to go fuck yourself. The words lasted only a few seconds. The consequences lasted much longer. Eventually, the event ended. The guests left. The vehicles disappeared. The neighborhood became quiet again. But something had changed. Neither neighbor forgot the confrontation. And after that day, almost every interaction carried a little more tension than before. Discussions became disagreements. Disagreements became accusations. Simple questions became sources of suspicion. Looking back, the parking dispute seems almost insignificant. No police reports, no lawsuits, no judges, just two neighbors who had gotten off to a very bad start. But that is often how these conflicts begin. Not with a dramatic event, not with a major legal issue, with a single moment that changes how two people see each other. For Christopher Brestelli, the argument was over. For Benjamin Whelan, it wasn't. because in the months that followed, another dispute began to develop. This time it involved the waterfront, plans for a dock, access to the lake, and a structure that would eventually become the center of the entire case: a 6-foot fence. And once construction began, there would be no turning back. The argument at the wedding shower should have been the end of it. Instead, it became the beginning. In the months that followed, the relationship between Benjamin Whelan and Christopher Brestelli remained tense. The two men no longer viewed each other with the benefit of the doubt. Every disagreement felt deliberate. Every decision felt personal. Then, in the spring of 2019, Christopher Brestelli moved forward with a project that would transform the dispute. He wanted a dock. For lakefront homeowners, a private dock is more than a convenience. It is access. It is recreation. It is one of the most valuable features a waterfront property can have.
According to court records, the Brestellis began the process properly. They sought the necessary approvals. They worked through the required channels. Eventually, they obtained permission from both local authorities and the owner of the lake itself. The project was moving forward. But there was a complication. The path leading from the Brestelli property to the lake passed directly behind the Whelan residence. Every trip to the dock would bring family members, guests, and visitors through an area visible from the neighboring property. And by this point, Christopher Brestelli had little reason to believe those interactions would be friendly. The hostility from the wedding shower had never truly disappeared. The dock was supposed to improve life on the lake. Instead, it became the next battleground. Christopher decided he needed privacy.
Not just for himself, for his family, for guests visiting the property, for everyone using the dock. So he made another decision, a decision that would define the next phase of the conflict. He built a 6-foot wooden stockade fence. From Christopher's perspective, the reasoning was straightforward. The fence created separation. The fence created privacy. The fence shielded the route leading toward the lake. But when Benjamin Whelan saw the structure, he saw something entirely different. He saw a wall. The fence rose along the boundary between the properties. And almost immediately, it changed what Whelan saw when he looked toward the water. The open view that had existed before was no longer the same. Part of the lake disappeared behind wood and posts. The fence did more than divide two properties. It changed the landscape. And that wasn't the only problem. According to the court record, the fence also created a practical obstacle. Near the boundary stood utility poles serving the Whelan property. The new fence interfered with access to them. Now the dispute was no longer just about aesthetics. It was no longer simply about a lake view. It involved physical access, property use, and infrastructure connected to the home itself. The conflict escalated immediately. Whelan did not view the fence as an ordinary property improvement. He viewed it as a direct attack on his enjoyment of the property. And unlike the argument at the wedding shower, this was not something that would disappear when guests went home. The fence remained. Every day, every morning, every evening, every time he stepped outside. For Christopher Brestelli, the project was complete. For Benjamin Whelan, the fight was just beginning. The dispute quickly expanded beyond conversations between neighbors. Whelan began challenging the dock project itself. If the dock could be stopped, perhaps the larger conflict could be stopped with it. According to the record, he filed complaints with multiple municipal agencies. 3 separate agencies would eventually receive objections connected to the project. The goal was clear:
prevent the dock from moving forward, force the authorities to take another look, force someone else to intervene. The complaints triggered reviews. Questions were asked, documents were examined, but the outcome was not what Whelan wanted. The challenges failed. The permits remained in place. The dock survived. And from the Brestelli perspective, the situation had crossed a line. Christopher no longer saw the dispute as a disagreement between neighbors. Now, there were government complaints, official filings, challenges to approved permits, time, money, stress. The conflict was becoming expensive, and expensive conflicts rarely get smaller. They get lawyers. By the summer of 2019, both sides were deeply entrenched. Neither family appeared willing to back down. The dock had survived. The fence remained standing. The hostility continued growing. What had started with parked cars at a wedding shower had evolved into a full-scale property war. And the next move would not come from a town official. It would not come from a lake authority. And it would not come from another angry conversation near the property line. It would come from an attorney. Because Christopher Brestelli had reached his own conclusion. If this dispute was going to continue, it would no longer be handled neighbor to neighbor. It would be handled in court. And once lawyers became involved, the fight entered an entirely different phase. By the summer of 2019, the dispute between the Whelans and the Brestellis had reached a breaking point. The dock had been approved. The fence remained standing. And Benjamin Whelan's attempts to stop the project had failed. The complaints he filed with local agencies had triggered reviews and investigations, but none of them produced the result he wanted. The permits remained valid. The dock remained legal. And the conflict continued. From the Brestelli perspective, the situation had become intolerable. What had started as a disagreement between neighbors had evolved into something far more serious. There had been arguments, complaints, government filings, challenges to approved permits, and constant hostility between two families living only a few feet apart. Christopher Brestelli eventually decided that the dispute could no longer be handled through conversations, emails, or municipal agencies. He hired an attorney. That decision changed the direction of the conflict. Because once lawyers became involved, the dispute stopped being a neighborhood disagreement. It became a lawsuit. According to the court record, the Brestellis filed a civil action against the Whelans, asserting a remarkable list of claims. They accused the Whelans of trespass. They accused them of defamation. They alleged nuisance. They alleged negligent misrepresentation. They claimed obstruction of an easement. They sought damages for both intentional and negligent infliction of emotional distress. And they also sought to quiet title regarding disputed property interests. By this point, the case was no longer about a fence. It was no longer about a dock. It was no longer even about a lake view. The lawsuit painted a picture of two neighboring families whose relationship had completely collapsed. Every disagreement was now being translated into legal language. Every accusation carried potential financial consequences. Every interaction became part of a growing court record. For the Whelans, the lawsuit represented a dramatic escalation. Benjamin Whelan had filed complaints with local authorities. Now, he was being sued. And not for one issue, for many. The legal papers described a conflict that had spread into nearly every aspect of the neighboring properties. Attorneys became involved. Documents were exchanged, evidence was collected, photographs were reviewed, property records were examined. Both sides began preparing for a long legal fight. And long legal fights are expensive.
Months passed. The attorneys continued working, the bills continued growing, and the hostility between the families showed no sign of disappearing. At some point, a difficult reality became impossible to ignore.
Even if one side eventually won, the cost of getting there could be enormous. Trials cost money. Discovery cost money. Experts cost money. Every month that passed increased the financial pressure on both families. The lawsuit had become a burden for everyone involved. Eventually, discussions about settlement began. At first, the conversations were cautious. Neither side trusted the other. Neither side wanted to appear weak. But both sides understood something important. Continuing the war might cost more than ending it. The negotiations slowly moved forward. Lawyers exchanged proposals, terms were discussed, conditions were debated. The central issue remained the same: the fence, the structure that had transformed a disagreement into a lawsuit, the structure that blocked part of the lake view, the structure that had become the physical symbol of the entire conflict. As the negotiations continued, a possible resolution finally emerged. The Whelans would make a payment. The Brestellis would dismiss their lawsuit. Property issues would be resolved. Rights relating to the shared driveway would be addressed. A small parcel of land containing drainage infrastructure would be transferred. And most importantly, the fence would come down. For Benjamin Whelan, the proposal carried a bitter irony. He believed the fence had caused the problem. He believed the dispute should never have reached this point. Yet now, he was being asked to pay money in order to make the conflict disappear. The amount was not small. $15,000. $15,000 to end the lawsuit. $15,000 to restore peace between the neighboring properties. $15,000 to remove the fence. After months of legal warfare, the agreement finally appeared within reach. Lawyers prepared documents. Terms were finalized. Signatures approached. For the first time in a very long time, both families could see an end to the conflict. The nightmare seemed ready to end. What nobody realized was that the settlement itself was about to create an entirely new battle. And the most important fight in Whelan versus Brestelli had not even begun yet. The war had become expensive, very expensive. Eventually, both sides began searching for something they had not seriously considered in months: a way out. The discussions took place through attorneys, not neighbors. By this point, direct conversations between the families had become nearly impossible. Everything had to be negotiated. Everything had to be documented. Everything had to be reduced to written terms. Slowly, an agreement began to take shape. The proposal was ambitious. It was designed to resolve nearly every major issue dividing the properties. The lawsuit would end. The conflict over certain property rights would end. Questions involving access would be addressed, and the fence that had become the symbol of the entire dispute would finally be removed. The negotiations were not simple. Each side wanted concessions. Each side wanted protection. Each side wanted certainty. The attorneys worked through details that most people would never consider: property interests, access rights, drainage issues, future obligations. The goal was not simply to settle a lawsuit. The goal was to create a framework that would allow two neighboring families to live next to each other without immediately returning to court. According to the court record, the agreement ultimately required the Brestellis to transfer a small parcel of land containing drainage infrastructure. The agreement also addressed rights associated with the shared driveway. Multiple issues that had fueled the conflict were bundled into a single settlement package. But one term stood above all the others. $15,000. That was the amount the Whelans agreed to pay. Not the Brestellis, the Whelans. For Benjamin Whelan, the situation carried a painful irony. He believed the fence had caused the problem. He believed the conflict had spiraled out of control because of decisions made by his neighbor. And yet now, he was preparing to write a check, a very large check, $15,000. The payment was not a fine. It was not damages awarded by a judge. It was part of a negotiated settlement, a settlement designed to end the war. After months of litigation, the Whelans faced a difficult choice: continue fighting and spend even more money, or pay the settlement and move on with their lives. Eventually, they chose peace. The agreement was signed, the payment was made, the lawsuit would be dismissed. The property issues would be resolved, and most importantly, the fence would come down. For the first time in months, there appeared to be a genuine path forward. No more motions, no more hearings, no more legal threats. Just two neighboring families finally putting an end to a dispute that had consumed an entire year. Then, something remarkable happened. The fence was removed. Workers dismantled the structure. Posts came out of the ground. Sections disappeared. The barrier that had dominated the conflict was finally gone. Benjamin Whelan looked toward the lake. For the first time in a long time, the view was open again. The settlement appeared to be working exactly as intended. The attorneys had done their job. The conflict was over. Or at least, that is what everyone believed. Because settlements are built on a simple assumption. Both sides intend to honor them. Without that assumption, agreements are meaningless. And at that moment, nobody had any reason to believe the agreement would fail. The documents had been signed, the money had changed hands, the lawsuit was ending. The fence was gone. Everything pointed toward resolution. For a brief period of time, Benjamin Whelan allowed himself to believe the nightmare was finally over. The stress, the litigation, the arguments, the endless hostility. Perhaps all of it had finally reached its conclusion. Then, he noticed activity near the property line. At first, it did not seem important. A few measurements, a few markings, workers moving through the area. Nothing that immediately suggested trouble. But as the days passed, a disturbing realization began to form. The settlement had removed a fence. It had not removed the resentment. And resentment has a way of finding new forms. Soon construction began again. Not on the dock, not on the driveway, not on the drainage area. On the boundary itself. The same place where the original conflict had exploded. The same place covered by the settlement. The same place where everyone believed the dispute had finally ended. Benjamin Whelan watched in disbelief as a new structure started to rise. The lawsuit was ending. The payment had already been made. The agreement was already signed. Yet another fence was being built. And in that moment, a troubling question emerged. Had the settlement ended the conflict, or had it merely paid for the next chapter of it? For a short time, Benjamin Whelan believed the dispute was finally over. The settlement had been signed, the lawsuit was being dismissed, the payment had been made, and the fence, the structure that had dominated nearly every stage of the conflict, had been removed. After months of arguments, legal filings, attorney meetings, and mounting expenses, there was finally silence. The barrier was gone. The lake was visible again. And for the first time in a very long time, the neighboring properties looked almost normal. The agreement had cost the Whelans $15,000. It was not an easy decision. Benjamin Whelan believed the conflict should never have reached that point. Yet he had accepted the settlement because it offered something more valuable than money. It offered finality, a chance to stop fighting, a chance to stop paying lawyers, a chance to stop waking up every morning and seeing the dispute sitting in his backyard. The agreement was supposed to create a fresh start. Instead, it created one of the most important questions in the entire case. The first signs appeared only days later. At first, nothing seemed unusual. Workers occasionally appeared on the Brestelli property. Materials arrived, measurements were taken. People moved around near the boundary line. Construction activity is common around lakefront homes. There was no immediate reason to assume anything was wrong. But as the days passed, Whelan noticed something troubling. The activity was concentrated in a very familiar location, the property line. The same property line that had generated years of conflict. The same property line addressed by the settlement. The same property line where the original fence had stood. At first, he hoped he was mistaken. Perhaps the work involved landscaping. Perhaps it involved drainage. Perhaps it involved one of the many property issues addressed during the negotiations. But then, the posts appeared. Fresh posts. New posts, placed in the ground with a purpose that was impossible to misunderstand. The realization hit immediately. Another fence was being built. Not repaired, not modified, rebuilt. For Benjamin Whelan, the site was almost impossible to process. He had just paid $15,000. The original fence had already come down. The settlement was barely complete. And now, another structure was rising in almost the same area. Every day brought more progress. Additional sections appeared. More panels were installed. The outline became clearer. The shape became unmistakable. The fence was returning. The reaction was immediate. Shock, confusion, disbelief. Then, anger. Because from the Whelans' perspective, the entire purpose of the agreement had been defeated. The settlement had not been cheap. It had required significant concessions from both sides. The lawsuit was being withdrawn. Property issues had been resolved. Land was being transferred. Driveway rights were being addressed. Money had changed hands. And one of the central expectations underlying the agreement was that the conflict surrounding the fence would finally end. Yet here it was again, standing in the same neighborhood, creating the same tension, triggering the same questions. The timing became impossible to ignore. Had Christopher Brestelli always planned to build another fence? Had he already made that decision before signing the agreement? Or had something changed afterward? Those questions would eventually become critically important, because settlement agreements depend on a concept known as good faith. When two parties negotiate an agreement, each side is expected to act honestly and fairly in carrying out its obligations.
The legal system assumes that people are not secretly planning ways to defeat the very agreement they are signing. And that assumption now appeared to be under attack. The Whelans began looking more closely at what had happened. The sequence of events bothered them. The original fence came down. The settlement became effective. Then, almost immediately, construction began again. The timeline felt wrong. Too fast, too convenient, too predictable. It looked less like a new decision and more like an old plan finally being carried out. The conflict quickly reignited. The hostility everyone thought had been buried returned almost overnight. Phone calls were made. Questions were asked. Lawyers became involved once again. What had looked like a successful settlement was starting to resemble a temporary pause in a much larger war. And as the tension returned, the dispute began expanding in new directions. The fence was no longer the only source of concern. The Whelans started noticing something else around the Brestelli property. Small devices mounted in visible locations. New equipment facing outward. Objects that seemed designed to observe rather than protect. At first, they appeared harmless, but over time, their presence became impossible to ignore because the conflict was evolving. It was no longer just about property boundaries. It was no longer just about lake views. It was no longer just about fences. The neighbors were about to enter a new phase of the dispute, one involving surveillance, one involving privacy, and one that would eventually produce some of the most disturbing allegations in the entire case. The new fence had restarted the war. The cameras were about to make it personal. The new fence reignited the conflict. Whatever peace the settlement agreement had briefly created disappeared almost immediately. The attorneys were involved again. The neighbors no longer trusted one another, and every action was viewed through the lens of suspicion. By this point, the dispute had already survived arguments, government complaints, a lawsuit, a settlement agreement, and the construction of 2 separate fences. Most people would have expected the conflict to stabilize. Instead, it evolved. The next phase did not involve another structure. It involved surveillance. At some point after the settlement, Christopher Brestelli installed 4 surveillance cameras around his property. He also placed multiple surveillance warning signs. The cameras were visible. The signs were visible. And that visibility mattered. Because in neighborhood disputes, perception can become just as important as reality. The cameras quickly attracted attention. The warning signs attracted attention. And before long, they became another source of tension between the neighboring properties. From the Brestelli perspective, the cameras served a straightforward purpose. The conflict had already produced years of hostility. Government complaints, legal claims, property disputes, arguments involving access rights. The relationship between the neighbors had completely broken down. Security cameras offered documentation. Security cameras offered protection. Security cameras created a record. In many situations, that would have been the end of the story. But this was not an ordinary neighborhood, and this was not an ordinary dispute. For the Whelans, the cameras felt different. The devices appeared during one of the most hostile periods of the conflict. The new fence had already created fresh resentment. The settlement itself was being questioned. Trust had vanished. Against that backdrop, the cameras felt threatening. Not because of what they were proven to record, but because of what the Whelans believed they represented. Every time they stepped outside, the cameras were there. Every time they looked toward the neighboring property, the cameras were there. The warning signs reinforced the feeling. The message was impossible to miss. You are being recorded. Whether or not that was the intended message, it was the message received. And over time, that perception became part of the dispute itself. The Whelans eventually claimed that the surveillance equipment had been installed as part of an ongoing campaign of harassment. From their perspective, the cameras were not simply security devices. They were tools of intimidation. Another way to make life uncomfortable. Another way to remind them that the conflict was still alive. The allegations became serious enough that they eventually appeared in court. Once again, a judge was asked to examine the behavior of the neighbors. Once again, the conflict moved from personal accusations to legal analysis. And once again, the answer turned out to be more complicated than either side wanted. According to the court record, the trial court examined the placement and purpose of the cameras. The evidence showed that the devices were positioned to monitor the Brestelli property. Particular attention was given to areas surrounding the shared driveway and access routes connected to the dock. The court did not find evidence that the cameras had been directed into the Whelan home. The court did not find evidence that the cameras had been intentionally positioned to invade private living spaces. That distinction became critical because the Whelans had asserted a claim based upon invasion of privacy. The court ultimately rejected that claim. The judge concluded that the installation of the cameras and warning signs constituted a legitimate security measure. The conduct did not rise to the level of an unreasonable intrusion upon the Whelans' privacy. Legally speaking, Christopher Brestelli prevailed on that issue. But legal victories do not always resolve personal conflicts. In fact, they sometimes make them worse. Because the court's ruling did not change how the neighbors felt. The cameras remained. The signs remained. The hostility remained. And perhaps most importantly, the feeling of being watched remained. Whether that feeling was legally justified became almost irrelevant. It had already become emotionally real. The conflict was no longer focused solely on property rights. It was becoming psychological. The neighbors no longer argued only about fences and lake access. Now, they argued about privacy, intent, motivation, and what each side believed the other was trying to accomplish. Then, the dispute expanded once again. This time, the conflict would leave the ground entirely because the next allegation involves something moving above the properties, something capable of seeing far more than a fixed security camera. A drone. And before long, both neighbors would be accusing each other of using the sky as the newest battlefield. The cameras changed the atmosphere between the two properties, but they were fixed. They stayed where they were mounted. They watched only what their placement allowed them to watch. The next phase of the conflict was different, because this time, the object at the center of the dispute could move. It could cross angles. It could rise above fences. It could look down into places that no camera mounted to a wall could easily reach. A drone. By this point, the relationship between the Whelans and the Brestellis had become almost impossible to repair. The settlement had failed to bring peace. The new fence had reignited the dispute. The cameras had created fresh accusations. And every new detail seemed to push both families further away from any realistic chance of normal neighborly life. Then, the conflict moved into the air. According to the court record, drone activity became part of the dispute after the cameras and the second fence had already deepened the hostility between the properties. And it was Christopher Brestelli's son,
Travis, who took the fight into the sky. The Whelans believed they were being monitored. The Brestellis believed they were protecting and documenting their own property interests. Neither side trusted the other's explanation. And once a drone entered the story, the suspicion became even harder to contain. A fence can block a view. A camera can be pointed at a driveway. But a drone changes the emotional weight of a dispute. It creates the feeling that the conflict has no boundary anymore. Not the property line, not the fence, not even the air above the backyard. For the Whelans, the drone became another sign that the conflict had moved beyond ordinary property disagreement. From their perspective, it was not just about land anymore. It was about being watched, tracked, observed, documented. From the Brestelli perspective, the situation looked different. They had already been dragged through government complaints, property disputes, a lawsuit, and a settlement that immediately collapsed into another fight. In that kind of environment, documenting what happened around the property could be viewed as protection. Evidence, a record, a way to avoid relying only on memory when the next accusation arrived. That was the problem. The same act could look completely different depending on which side of the fence you were standing on. To one family, the drone was surveillance. To the other, it was documentation. To one family, it was intimidation. To the other, it was evidence. And by this stage, the court would eventually have to sort through not only what happened, but what the conduct legally meant. The drone did something the fence and cameras could not do. It turned the dispute into a question of space. How much control does a homeowner have over the area around a property?
What counts as legitimate observation? When does documentation become harassment? And when does a neighbor's attempt to protect himself become an unreasonable intrusion into someone else's life? Those questions did not have simple answers, but they made the conflict feel larger. The backyard was no longer just a backyard. The dock was no longer just a dock. The fence was no longer just a fence. Every object had become part of a legal story. Every movement had potential meaning. Every photograph, video, complaint, and observation could later be examined by attorneys. The drone represented the most visible sign that the dispute had escaped ordinary limits. It was no longer confined to a property line. It was no longer confined to the shared driveway. It was no longer confined to the route toward the lake. The conflict had expanded vertically. And for the Whelans, that made the situation feel inescapable. If they looked toward the property line, there was a fence. If they noticed the house next door, there were cameras. And if they looked above the yard, there could be a drone. Whether the court would ultimately agree with their interpretation was a separate question. But emotionally, the damage was already done. The relationship between the neighbors had become defined by suspicion. Nobody assumed ordinary motives anymore. Nobody assumed coincidence anymore. If something happened, the other side believed there was a reason. If equipment appeared, the other side believed there was a purpose. If someone recorded, watched, complained, or responded, it became another entry in the history of the conflict. And that history was growing fast. The drone accusations did not replace the fence dispute. They layered on top of it. They did not erase the settlement issue. They made it worse. Because now, the court would eventually be looking at a conflict that included property rights, contract obligations,
privacy claims, surveillance equipment, warning signs, and aerial observation. The case had become much bigger than the first fence. And yet, the most important evidence still had not appeared.
Because the drone made the dispute feel dramatic. The cameras made it feel personal. The second fence made it feel deliberate. But the real turning point would come later. Not from a photograph, not from a warning sign, not from a flight over the property. It would come from testimony, from a question asked under oath, and from an answer that would force the court to look back at the settlement agreement in a completely different way. Because the most damaging evidence in Whelan versus Brestelli was not in the sky. It was on the witness stand. By the time the case reached trial, the conflict between the Whelans and the Brestellis had become a maze of accusations, documents, property records, photographs, and competing narratives. Years had passed since the first argument. The wedding shower, the dock, the original fence, the lawsuit, the settlement agreement, the replacement fence, the cameras, the drone allegations. Each event had added another layer to the dispute. But as the court reviewed the evidence, one issue began to dominate everything else.
The settlement agreement. Not whether it existed, not whether it had been signed. Everyone agreed on those facts. The real question was whether Christopher Brestelli had ever intended to honor it. For Benjamin Whelan, the answer seemed obvious. He had paid $15,000. The original fence had been removed. Then, another fence appeared almost immediately. From his perspective, the promise of peace had lasted only long enough for the ink to dry. But courts do not decide cases based on feelings. They decide cases based on evidence. And eventually, the evidence led directly back to the replacement fence.
Attorneys began reconstructing the timeline. Not the timeline after the settlement, the timeline before it. That distinction would become critical. The court examined what Christopher Brestelli knew while the settlement negotiations were still taking place. What had he planned? What decisions had already been made? What preparations had already begun? The answers revealed something far more significant than anyone expected. According to the evidence discussed during the litigation, Brestelli had not simply thought about building another fence. He had already begun preparing for it. Before the settlement process had fully concluded, before the original fence had even been removed, materials for the replacement fence had already been purchased.
Posts, construction materials, components needed for the new barrier. The evidence suggested that preparations were already underway, while both sides were supposedly working toward a final resolution. That fact changed the entire case. Because the dispute was no longer about whether Brestelli had the legal right to build a fence. Property owners frequently build fences. That was never the central issue. The issue was timing, intent, good faith. The court now faced a troubling question. If Brestelli was already purchasing materials for a replacement fence while the settlement negotiations were still ongoing, what exactly had the Whelans paid $15,000 for?
The original fence had come down. That much was true. But if a replacement was already being planned before the agreement was completed, the settlement suddenly looked very different. The negotiations looked different. The promises looked different. Even the removal of the original fence looked different. What had appeared to be cooperation could instead be viewed as a temporary step
toward the same premeditated outcome. The attorneys focused heavily on that point. The replacement fence was no longer merely a structure. It had become evidence. Evidence of intent. Evidence of planning. Evidence of what Christopher Brestelli expected to happen after the settlement was complete. As testimony continued, the timeline became increasingly difficult to ignore. The sequence of events fit together too neatly. The original fence came down. The settlement became effective. Construction activity began, and the replacement fence appeared. Viewed in isolation, each step might have seemed harmless. Viewed together, they created a much larger question. Had the settlement ever been given a genuine chance to succeed? For the Whelans, the answer was no. They argued that the agreement had been negotiated on the assumption that the fence dispute would finally end. That assumption had value. A value measured in $15,000. A value measured in months of negotiations. A value measured in the decision to abandon further litigation. The replacement fence threatened all of it. The court now had to decide whether Brestelli's conduct reflected legitimate property management or something else entirely. Something more calculated. Something that struck at the heart of the settlement itself. The legal phrase repeatedly appearing beneath the surface was good faith. Parties entering settlement agreements are expected to act honestly. They are expected to carry out their obligations in a manner consistent with the purpose of the agreement. The question before the court was no longer whether another fence existed. Everyone knew it did. The question was whether Brestelli had already decided the outcome before the settlement was finalized. If so, the implications were enormous, because the dispute would no longer be about a fence. It would be about the integrity of the settlement process itself. By now, the cameras had faded into the background. The drone allegations had faded into the background. Even the original lawsuit mattered less than before. Everything revolved around one discovery. The replacement fence may not have been an afterthought. It may have been part of the plan all along. And once the court reached that conclusion, only one thing remained: the ruling. After years of conflict, thousands of dollars in legal fees, countless accusations, and one remarkably expensive attempt at peace, the judge finally had to answer the question that had haunted the case from the beginning. Did Christopher Brestelli honor the settlement agreement? Or had Benjamin Whelan paid $15,000 for an illusion? The legal battle did not end at the property line. It did not end with the second fence. It did not end with the cameras. And it did not end with the drone allegations. After years of conflict, the final outcome of Whelan versus Brestelli would be decided in a courtroom. By the time the trial court examined the evidence, the dispute had become far more complicated than the argument that started it. What began as a disagreement between neighbors had evolved into a case involving contracts, property rights, easements, privacy claims, settlement obligations, and years of accumulated hostility. Yet despite the complexity, the court ultimately focused on a surprisingly simple question. What exactly had Christopher Brestelli promised when he entered the settlement agreement? The judge began with the timeline. Not the accusations, not the emotions. The timeline. The Whelans had paid $15,000. The original fence had been removed. The lawsuit had been resolved. On paper, the settlement appeared successful, but the evidence told a different story. The court reviewed testimony. The court reviewed documents.
The court reviewed the sequence of events surrounding the replacement fence, and one fact stood above all the others. Christopher Brestelli had already begun preparing for the new fence before the settlement process had fully concluded. Materials had already been purchased. Plans already existed. The replacement barrier was not the product of a later disagreement. It was already taking shape, while the parties were supposedly negotiating peace. That finding changed everything.
The issue was no longer whether Brestelli possessed the technical right to construct a fence on his property. Property owners build fences every day. That was never the central issue. The issue was whether he had honestly participated in the settlement process, whether he had acted in good faith, or whether he had accepted the benefits of the agreement while quietly preparing to defeat its purpose. That distinction became the heart of the case. Under Connecticut law, contracts carry what courts describe as an implied covenant of good faith and fair dealing. In simple terms, parties are expected to act honestly and fairly. A contract cannot be used as a trap. A settlement cannot be negotiated while one side secretly plans to undermine the very benefit the other side is paying to obtain. The judge concluded that this was exactly what had happened. According to the court's findings, Christopher Brestelli's conduct amounted to an evasion of the spirit of the bargain. The phrase would become one of the most important descriptions in the entire case. The settlement was supposed to end the fence dispute. The Whelans had paid for that outcome. Yet the evidence showed that a replacement fence was already being prepared before the agreement had even been fully carried out. The court determined that Brestelli had deprived the Whelans of the benefit they had bargained for, and that meant the settlement agreement had been breached. But the ruling did not stop there. The court also examined the nature of the replacement structure itself. Was it simply a fence? Or was it something more? Connecticut law recognizes a specific category known as a spite fence. A structure erected not for a legitimate purpose, but primarily to annoy, injure, or interfere with a neighboring property owner. The evidence convinced the court that the replacement fence met that definition. This was not viewed as an ordinary improvement. It was viewed as a continuation of the conflict, a barrier designed to interfere with the neighboring property owner's reasonable enjoyment. The legal consequences were severe. The court ruled in favor of the Whelans. The court found that the settlement agreement had been violated. The court found that the replacement fence constituted a spite fence. And because the dispute centered on the breach of the settlement itself, the financial consequences became significant.
The Brestellis were ordered to pay the Whelans attorney's fees. They were ordered to pay court costs. The conflict that Christopher Brestelli believed he had won by rebuilding the fence had now become an expensive legal defeat. For most people, that would have ended the matter. Not here. The Brestellis appealed. They challenged the findings. They challenged the conclusions. They challenged the award of attorney's fees. And they challenged the classification of the fence itself. The dispute moved to the Connecticut Appellate Court. Months passed. Judges reviewed the record. Transcripts were examined. Testimony was analyzed. The timeline was scrutinized once again. The appellate judges looked at the settlement. They looked at the purchase of the fence materials. They looked at the replacement structure. And they looked at the trial court's reasoning. Then, on February 18, 2025, the appellate court delivered its answer. The higher court affirmed the judgment. The findings remained intact. The conclusion remained unchanged. The evidence supported the determination that Christopher Brestelli had violated the settlement agreement. The evidence supported the finding that he had acted contrary to the obligations of good faith and fair dealing. And the evidence supported the trial court's conclusions regarding the replacement fence. After years of litigation, the result was final.
The legal system had reached its answer. The war that began with parked vehicles at a wedding shower had traveled through municipal complaints, a dock dispute, 2 fences, surveillance cameras, drone allegations, settlement negotiations, and multiple court proceedings. In the beginning, Benjamin Whelan paid $15,000 believing he was purchasing peace. Instead, he purchased another round of conflict. But in the end, the courts forced his neighbor to bear the far greater cost. Not because of the fence itself, but because of what happened when he chose to break his word. And that decision ultimately became the most expensive mistake in the entire neighborhood war.